Okay, we'll get started. Thank you, everyone. My name is Valerie Boyd, and I'm the Director of the Center for Presidential Transition at the Partnership for Public Service. For those of you not familiar with the partnership, it is a nonpartisan nonprofit working to build a better government and stronger democracy through leadership development, workforce programming, and convening conversations like this one to help support the federal workforce. We know many of you are here because you have a lot of questions about the executive actions taken over the past 2 weeks and how they impact you, your families, your colleagues, and also the mission of your agencies and the people across the country and around the world who rely on and interact with our federal agencies and programs. We know there's a lot of confusion and anxiety out there. We feel this on a personal level too, especially because so much of this is happening quickly and without a lot of time to work through it all. We're here to support you as best as we can through resource sharing, providing plain language explainers like this one, and continuing to do what is the hallmark of the partnership, sharing the stories of the incredible work that federal employees do across the country. Tonight, we'll dig into some of the actions that are currently impacting federal employees, including deferred resignation and buyouts, reductions in force or RIFs, reassignments, administrative leave, early retirement, and other topics as we can get to them. Before we kick things off, I need to make a few housekeeping notes. First, I need to provide the disclaimer that the information provided during this session is for informational purposes only. It is not intended to provide legal advice. The information presented is general and provides an overview of the current processes around various employee actions and is not intended to provide any legal guidance. If you require legal advice, we recommend consulting with a qualified attorney who can assess your unique circumstances. Second housekeeping note, we are doing our best to analyze these issues in real time, but as I mentioned, they often leave more questions than answers at this point. So throughout the webinar, we will seek to answer some of the hundreds of questions that you submitted while registering, and you can also submit a question anonymously through the Q&A function. My colleague Carrie from our Government Affairs team is joining us to help dig through the questions in the chat and be responsive to your real-time questions. We're not going to be able to answer every question tonight, but we have scheduled a series of explainer sessions over the next few weeks to dig into additional topics. So while we may not get to a certain topic this evening, you may find the dates of future seminars coming up soon at ourpublicservice.org. And we will be posting all of these explainer series on our resource hub for federal employees, also at ourpublicservice.org. Third, and finally, while this discussion is geared for current federal employees, it is an open forum, and we may have folks joining us from other outside communities like good government groups, the media, and the private sector. We welcome you here, but wanted to flag that we will not be going into how these issues may impact those communities. So whether or not your question is answered tonight, we do encourage you to reach out to your agency HR staff and seek legal guidance from your agencies or an outside attorney and continue to support each other. So at long last, I'd like to introduce Ron Sanders, who has had a long career managing human capital at federal agencies and is joining us tonight to help answer your questions. Ron, I won't do justice to the many ways you have managed these questions at complex agencies. So could I ask you to please introduce yourself?
Sure. Thanks, Valerie. And I hope our viewers will join me in my condolences and sympathies to Valerie because she's drawn the unenviable task of trying to keep my mouth shut. And we've worked out a complex series of hand signals for her to tell me to be quiet. They sort of go like this. So when you see her go like this, that means I'm to be quiet. Look, I'm only being partly facetious, although I will piggyback on something that Valerie said. I'm going to take us upstream a bit. I'm going to counsel everybody to take a deep breath and to think about your own individual circumstances, because frankly, those are what's most important today. And those individual circumstances, whether you share them with an attorney, an agency HR specialist, a former like me, the partnership, doesn't matter. It's those individual circumstances that will determine your final decision. And as Valerie's indicated, there's a lot going on. I wish I could say we had all the answers. I wish I could say that the people who are promulgating all those things had all the answers. They don't. We don't, but we'll certainly give it a shot. So with that, I will tell you, I'm sure you can see my bio on the partnership website. And I will, as Valerie's indicated, I've had a long and sordid career in the federal government, mainly in HR and mainly as a career civil servant, 40 years plus as a career civil servant, 20 as a senior executive, to include positions in DoD and IRS and the intelligence community and OPM. And I'm going to unfortunately share some war stories with you about those posts. And in particular, in thinking about this evening, my time in DoD as director of civilian personnel when in the early 90s, we were faced with a circumstance very much like this. Maybe different in tone, but in terms of target, we were in desperate search for a peace dividend. The Cold War was over, at least we thought so. Boy, were we naive. But the Cold War was over, and the country was demanding that we free up what at the time was a huge $500 billion DoD budget and redirect it to domestic programs and balancing the federal budget. And so we had to take some steps, very much like the steps being taken today to reduce the size of government. So I'll channel those as we go along. But Valerie, that's more than enough introduction from me. Again, my sympathies to you for having to keep me from droning on. Over to you.
Well, Ron, we're very lucky to have your expertise answering questions. And I think what you are joking about is for those people with long expertise on these issues, it is hard not to have an opinion. And what we're trying to do is provide facts about how some of these practices work, so that everyone can use those to help make their own decisions. But let's dive into the hard stuff.
Well, let
What's
me
on
just add, Valerie, sorry to interrupt, but I do have an opinion, but I'm going to try to make this as apolitical and nonpartisan as possible. So again, I'm going to depend on those subtle hand signals of yours if I get out of bounds. But secondly, let me just start off by saying what I plan to say at the end as well. For everybody listening, at least for those civil servants listening, thank you for your service. We need you. We need you now more than ever because I don't know whether the American people realize what they have voted to do. You know, it's easy to vote against the size of government. It may be too big. It's much harder to vote against cutting an individual department or an individual program. And that's what it comes down to. So, again, we need you now more than ever. And I know that the partnership and Max and Valerie and others feel the same way. So, again, thank you for your service.
That is a good place to start, Ron. Thank you. I do feel the need to dive right into the hard stuff at the top. What's on the minds of many federal employees right now is the deferred resignation or the fork in the road offer, and its deadline less than 2 days from now. So can we start by asking you to explain how is this offer different than traditional buyout or resignation options available to federal employees?
So, it is not, repeat, not a buyout. It is a resignation, and I'll come back to that, but it is not a buyout. A buyout, technically speaking, is voluntary separation incentive pay, capped at $25,000. It's been $25,000 since fiscal 1992, back when I was young and didn't have any gray hair. DoD managed a couple of years ago to get that up to 40,000, but for DoD only. But again, this is not, repeat, not a buyout. Having said that, it is a resignation offer. And personally, I think that the folks who promulgated it are on sound legal grounds. I know OPM has just come out with a memo saying as such. Frankly, I've been saying that for some time. They can do what they want to do. There is legal standing for them to do it. Resignations, while there's some recent legislation that governs a cap on resignations and on administrative leave, largely to avoid endless interminable investigations. For the most part, putting somebody on administrative leave with a quote deferred resignation is legal. And frankly, I think the people who promulgated it are being very creative. Having said that, again, I'm going to put my old DoD hat on and then take it off. My old DoD hat on, Deadlines work. We gave deadlines back then. We treated civil servants differently. We thanked them for their service. They had just won the Cold War, but we still had to say at the end of the day, goodbye. Look, maybe that's what this administration is after. Deadlines are important, but I really, really, really worry if I take that hat off. I really, really, really worry about people making a rash, rush decision. They should not. If they are ready to make a decision, make it. I just heard I did a television interview with one of your local Washington channels earlier today, and the commentator characterized this as a fork in the eye alternative. Not fork in the road, but fork in the eye. Look, if it works for you, do it. The deadline is important. If I were promulgating this, I would have established a deadline too. But taking that DoD hat off, don't make a decision based on that deadline. Make a decision based on your personal circumstance. The deferred resignation is, in my view, legal, and it doesn't require an additional appropriation. It is not, repeat, not a buyout. And agencies are given very, very, very wide latitude in the effective date of somebody's resignation. So, do what's right for you. Let me just add one other thing. If you resign, whenever you do, if you resign and then later have second thoughts, I'm here to tell you, an agency does not need to accept your recantation. If you resign tomorrow and then in a month decide, well, wait a minute, not for me, it's up to the agency to accept that or stand on your original resignation. So just be careful of what you're going to do over the next couple of days, weeks, and months.
This is a good moment to mention that if anybody hasn't looked at the OPM FAQs on their website, they also address that topic of whether someone can rescind their resignation. So you did a few important things in that response, which was saying a deadline is normal. I think that's helpful to hear. And you also explained what buyout authority looks like. For many of us who are new to federal HR issues, I think that the acronym VSIP is new to us. And I didn't know that the amount had not been updated since 1992. That explains something else. The other new term that we're hearing for many of us is voluntary early retirement authority, or VERA. And OPM said in their FAQ that some employees may be eligible for VERA as part of the deferred resignation offer. Can you explain what VERA is and who might
Sure.
qualify?
Basically, lots of folks are eligible for regular civil service retirement or FERS retirement. The formulas I won't bore you with. What OPM has now done, and they did it, at the end of last week, is add voluntary early retirement authority, otherwise known as VERA, VERA, to the mix. I'm going to take partial blame or credit for that because I've been saying all along, if you really want numbers, if your objective is to reduce federal headcount, that's neither good nor bad. It just is. If your objective is to reduce federal headcount, the best way to do it is to get people to leave early. And the people who can leave early are those with the most marketable skills, cybersecurity, nurses, STEM. If you can find a job right away in the private sector, take it. And unfortunately, those are the same skills we need in the federal government. But that's, again, if your objective is to reduce headcount, get these people to leave. Those people would resign. Doesn't matter what their years of service are. They're going to go because they have employment opportunities and alternatives. But adding VERA to the mix, Voluntary Early Retirement Authority, essentially adds thousands and thousands of employees to the eligibility list. Again, if you don't care what skills they have and you just want to reduce headcount, increasing the eligibility pool to include voluntary early retirement authority is a wonderful way to go. And my own DoD experience way back when was that when we added VERA to the mix, we got more or less the numbers that we needed. I don't know whether that's going to happen in this case. That's going to depend on the Friday deadline and what happens next. But I will say, adding voluntary early retirement to the mix is a good thing. And people who are on the cusp, who now know, wait a minute, I'm eligible for VERA, they know who they are because they've been watching the clock and the calendar. And if they're all of a sudden now eligible, to me, that does a couple of things. First, it increases the pool. We've already talked about that. But it also increases the trust factor. Because if you take early retirement, and first of all, agencies have pretty wide latitude as to when you take it. So let's say you say to your agency, I'm going to exercise my early retirement option in May. Early retirement is governed by a whole another set of laws and rules and regulations, and unless and until Congress changes them, those remain in effect. And in my humble opinion, if you exercise early retirement along with your departure, that just increases the trust factor that you have that what you've done will stick.
So that does feel like a helpful option that has been added into the mix that for some people creates better certainty about
It does. Now, again, let me belabor the point, Valerie. That's the case if all you're interested in is reducing headcount. Back in my DoD days, that's all we were interested in. We knew that blowing the whistle and telling everybody, get out of the pool, regardless of your skills, we knew that would result in long-term skills imbalances. And eventually, the government was going to have to hire to fill those skills imbalances. We thought, again, naively, Cold War is over. We can take our time correcting those imbalances. Let's just reduce headcount. I think that's what the folks behind the fork in the road or fork in the eye memo are after now. That is, they would just want to reduce headcount, skills imbalances notwithstanding. So if that's the case, this is legal. Just make sure that you've got your own individual circumstances at the forefront, not the government's.
So, speaking of individual circumstances, a lot of people are asking us about whether they would still get their leave payout as part of deferred resignation and whether they would also keep their health care and retirement benefits. And if it's not too complicated, what is the answer related to voluntary early retirement? Is there a different answer in that regard?
The only difference in the answers, Valerie, is has to do with trust. Because technically speaking, when you leave the government, whether you leave as through resignation or retirement, early or regular, you should get more or less the same benefits. Now, those benefits are tied to your tenure. And in some cases, you may not have vested yet, for example, for health benefits, health insurance. But let's assume for the moment that you're a very long tenured employee. Whether you exercise voluntary early retirement or whether you're short of that, even with that addition to the mix, let's pretend you're short of that, you still get severance pay. You still get the option of continuing your health benefits. Again, these are different laws and different rules. And unless and until Congress changes them, you got to take them with you. And again, I don't know this for a fact, but the people who are behind this, if their goal is to reduce government headcount, they're going to want to do that anyway. Now, there's a price tag to all of that, some direct, some indirect. But that price tag notwithstanding, at the end of the day, if you want to reduce headcount, that's the way to do it. And there is no difference in benefits. It's more, you can trust it more if it's tied to retirement. You can trust you have to decide yourself whether your agency is trustworthy if you're just going to resign. But if it were me, again, I'd still say, am I individually ready to do this? Deadline notwithstanding, benefits notwithstanding, it's just my employment options.
And let me ask one more question on this topic before we move on to other things that we're wondering about probationary periods. But on the deferred resignation offer, one of the kind of promises on the OPM website is that it allows the opportunity to seek other employment. So something that many people are wondering is if they take this authority, is there a restriction on seeking a new federal position? And are they governed by federal ethics rules if they're seeking an outside position?
Uh, yes, in part. So if somebody pays attention to the deadline and resigns as required, and they in part because they've got an employment opportunity in the private sector. If they want going to go to work for a government contractor, there are restrictions. Probably the most notable is something called the annuity offset, or in shorthand, a dual comp waiver. Unless OPM waives it, employees cannot come back and collect their total pension and their new government salary. So let's pretend you're a civil servant who resigns or retires. You can't come back and work for a different federal agency without worrying about that dual compensation waiver. Now, for me, I've argued to OPM they should be granting blanket dual compensation waivers because at the end of the day, if you retire under VERA or regular retirement, your pension comes out of the Civil Service Trust Fund. It's a different pot of money than your agency's payroll. And if the objective is to reduce your agency's headcount through payroll savings, it doesn't matter. You just want to cut bodies. And if you take retirement and you're collecting a pension, it's a different pot of money. If you go to work for a government contractor, you have got to be concerned about ethics rules in coming back to work, supporting your old agency.
Mm.
I would encourage you, if that's a possibility, to go to your agency ethics officer because there are restrictions there. Some are permanent. In my own case, I have permanent procurement restrictions in some instances. In other cases, they only last a couple of years. But there are restrictions in coming back as a contractor. But if you want to go to work for private industry, and it doesn't matter, you're not going to work for the government. You're not as a contractor or as a civil servant, reemployed annuitant. If you're just going to go work wherever, well, you still need to be contacting your agency ethics officer. There are really very few, if any, restrictions. You just go to work.
So I think that's very helpful. And Carrie, I see you are appearing likely because there's some very relevant questions in the chat right now.
Yes, thanks, Valerie. And good evening, everyone. Just wanted to underscore Valerie and Ron's earlier point that there's a lot of information moving very quickly. As we've seen, there's a new OPM memo today about this. There have been a series of FAQs released over the course of the last week, and would just encourage folks to continue to keep an eye on the information being shared. Wanted to flag that there is still a lot of conversation and trying to understand how some of these things might play out, what might be legal, what might not. So I know that it is challenging to ask folks to continue to keep an eye out for additional information. I know that everyone is seeking clarity and answers, and just wanted to remind folks to continue to keep an eye out for the information that's being provided from your agency and more broadly, and just to remind folks that we will likely continue to see some of these things being challenged as well.
Let me just underscore that too, if I may. So much of this depends on your agency's final appropriations, your agency's budget and final appropriations on the Hill in Congress. Remember, we're still operating under a continuing resolution. We flatlined the budget from when it was supposed to start last October. So at some point, Congress has got to weigh in. They will say, here's the overall budget, here's your agency's budget, here's an appropriation. And at the end of the day, whether it's implicit or explicit, your agency's headcount will be in that budget. And that will determine, by and large, what your final staffing levels will look like, and whether or not you should resign now, retire later, or stand pat. Again, so much of this depends on your individual circumstance. And Valerie, I hope we have a chance to talk about reduction in force, because I am here to tell you, as a hint to that, the people who are going to or are likely to be victims of reduction in force are not, repeat, not the same people who typically take retirement early or otherwise. Two different sets of folks.
Well, let's turn to reductions in force now, because I know this question is top of mind. As you said, you've managed this process at DoD under a sort of normal process for what it might look like. Can you start by explaining in plain terms what a RIF is?
So there's the blunt instrument and the scalpel. Reducing headcount through separation incentives, like deferred resignations or buyouts or whatever. That's the blunt instrument. The scalpel is reductions in force, where you literally, as an agency, take the time to identify surplus skills and surplus people and then cut them. Now, there's a lot that is packed into that. You have to first identify the surplus skills, then you have to build retention registers, and veterans status and performance rating all come into play. But here's sort of the bottom line up front, Valerie. A reduction in force is almost exclusively local, or at least limited to an agency. If you want to define a RIF, reduction in force competitive area, you can do that geographically. And in almost every case, especially given the particular bent of this administration, which is to get federal employees back into the office, those geographic definitions are going to be narrow. You could define a RIF competitive area as nationwide, but in that case, you're almost by definition sanctioning remote work. So I'm going to assume, without knowing, I'm going to assume that the RIF competitive areas are going to be narrowly defined geographically and locally. The RIF retention registers are going to be similarly defined narrowly. We're going to, if you have to, use a reduction in force, it'll be a scalpel, not a blunt instrument. But here's the key point. When I read headlines that say government-wide layoffs are coming, that ain't going to happen. RIFs are almost exclusively local, again, unless and until Congress changes all of the other laws involving reductions in force, and there are a lot of them. Unless those laws are changed, and let's assume for the moment that they're not, then there's never going to be a government-wide layoff. Your agency may lay people off, that's one thing, but there's not going to be a government-wide one. Now, that's sorry to take a long time here, but the people who are going to leave early, again, there are two kinds: those who are retirement eligible, both regular and early, and those who have other employment opportunities. The people with the most marketable skills. Those are not, repeat, not typically the victims of a reduction in force, because when you start bumping and retreating, that's a term of art, but it says more senior employees bump more junior employees, and it takes 4, 5, 6, 7 personnel actions in that daisy chain before you finally reach somebody who is out the door. And the way the seniority rules work, this is last in, first out. So if you don't have a lot of seniority, chances are you're not going to retire. And unless you've got a marketable set of skills, chances are you're not going to resign. So if you're on the cusp, if you just passed your probationary period or whatever, I'd worry, because you may be a victim of a reduction in force. But again, it's going to be local. It will not, repeat, not be government-wide.
And Ron, I'm jumping in. Sorry, Valerie. I'm jumping in just for a quick clarification in real time. Some folks in the chat wondering, when you say local, do you mean related to a specific geography, or concentrated in a particular agency or subcomponent?
Agency first, but then geography, typically commuting area.
So I think
it's almost exclusively going to be an agency, because again, as we've discussed, so much of this depends on your agency's final appropriation and whether that appropriation translates down to Chicago, Denver, Houston, Atlanta, Washington, D.C., and how many people are in those locales and what their skill sets are and all of those things. Look, I'm here to tell you, it takes a long time to run a RIF, at least relatively speaking. But again, it's a scalpel. It's not a blunt instrument. Sorry, Valerie.
No, that's exactly what I wanted to emphasize. So what you're saying about a RIF is that kind of separate from the deferred resignation offer, which has been made broadly to all employees, it's a bit more of a blunt instrument that agencies, specific to their appropriations, specific to their needs and their priorities, they may also look at where they need to make a reduction in force. And that would be specific to programs, geographical
Right,
regions.
right. Right.
So,
And again, just to belabor the point and give you yet another DoD war story. Way back then, we didn't care about location. We just wanted to reduce headcount. We wanted to reduce the roles. We actually had congressionally imposed end strength ceilings at the time. They're now illegal, but we had them at the time that said the department literally needs to reduce by 100 or 120 or 140,000 people this year. We didn't care where they came from. We just wanted them out because we thought we had time to correct the skills imbalances that would result. Again, I won't speak to the goals of the current administration, but if skills imbalances are the result, eventually they're going to have to be corrected. Many of them can be corrected by contractors, but that again, that's another matter.
so you mentioned it typically takes a long time to run a RIF. How long would that normally take, and how are employees notified when that's happening?
Well, if this may not happen, but if I were a chief human capital officer in an agency, I would tell folks we didn't get the headcount reductions that we needed, so we're going to have to run a RIF. Here's how we're going to run it. Again, location by location by location, retention registers, veterans first, everybody else second. Performance ratings matter. There's a retention order. It's basically seniority with a few things added, but at the end of the day, it's basically seniority. Now, typically it takes a while, but let me add another word to that, Valerie. Yeah, that's relatively speaking. Headcounts you're going to know Monday or next week whether enough people resign to reduce the federal government's roles to a level acceptable to the Doge or to OPM or to OMB or all of the above. Rifts take longer. They may take several weeks and even several months, depending on their complexity. But at the end of the day, you can get that done by this summer or by next fall, certainly by the beginning of fiscal 26. But oh, by the way, and this is something that too many appointees I've worked for, and I've been through count them, 9 presidential transitions, but too many appointees I've worked for, both Republican and Democrat, were stunned and surprised to learn they're already a year or two behind in terms of budget submissions and calculations and workforce planning and everything else. They're already a year or two behind. So we're already into the midterms. Again, so you've got to play your own individual circumstances and weigh the odds.
So this is helpful. We've gone through the differences between the deferred resignation offer, understanding it a little better. We've talked about reductions in force and how that is different and what they look like. Spend more time talking about each, but another topic that is forefront of a lot of people's mind is the probationary period. The concept that HR offices have compiled lists, that they've handed over lists of who is on a probationary period. I think the first thing we should ask is, how does someone know if they're in a probationary period right now?
Um, we talked about this earlier. If it were me, I'd print out a copy of my SF50 and SF52. I assume we still have those forms. That's going to tell you what your tenure is. But as a general proposition, if you're in the competitive civil service, you're a probationary employee for your first year. And unless the law is changed, unless and until your supervisor specifically comes to you and says you're fired, quote unquote, um, your probationary period will automatically lapse. You will become what's called a career conditional employee. You'll gain additional rights and benefits. And at some point, 2 years downstream from that, basically 3 years, you're going to become a career employee. In other words, you've got tenure.
Mhm.
And you've got protections. You still may have to serve a couple of more years in order for some things to vest, like your health insurance. But as a practical matter, all of the due process protections that are afforded folks in the competitive service apply when you're a career employee. Break. If you're in the accepted service, you're in what's called a trial period. That's not quite the same as a probationary employee, although many agencies have treated the two as synonymous. We can go into that detail if you want. But as a general matter, if you're in the competitive civil service and you have 1 year or less tenure, you're a probationary employee. And I have to tell you, this sounds harsh, but if OPM is compiling lists of you, I would bank on the fact that at some point somebody's going to say, get rid of all probationary employees, because agencies can do that with pretty much impunity.
That my next question was going to be, what rights and protections do people in their probationary period have? That you may have just answered that question.
Yeah, look, bottom line, very little. You're still protected by anti-discrimination laws and prohibited personnel practices, but you don't get any of the due process protections like notice and right to reply and right to representation and things like that. Now, some of that may be covered in a collective bargaining agreement. I won't comment on that. But as a general matter, if you're short of a year tenure, you're probationary. And if you're probationary, you can be let go literally without any notice. You're pretty much at will.
And some people are wondering if you were recently hired within the last year and you have changed roles during that year, does the clock reset?
As a general matter, no. Agencies could if they wanted, but that would have to be an affirmative agency determination. They could say, you spent 7 months in this role. We're now going to move you over here, and we're going to restart the clock on your probationary period. But I have to tell you, to me, that's pretty rare. For the most part, if you've passed your year, you're become a career conditional employee. And if you're 3 years in, you're a career employee and you are protected. Unless you're converted under this new policy/career schedule. But we can come to that later in the program.
Yeah, I think I know we want to dive into reassignments. A lot of people are experiencing those, and administrative leave, and the kind of guidelines and requirements around that. Before that, I should pause. I know Carrie's keeping a better eye on the chat than I am. Carrie, are there more questions before we leave the topic of deferred resignations, reductions in force, or probationary periods?
I think that there continue to be some questions about not only for folks who might be taking on a different role, but for folks who might have been government employees for any length of time, where they're out of their probationary period, if they switch agencies, if they become a supervisor. Just wondering if you can clarify, Ron, about at what points that clock might reset and reintroduce someone into a probationary period, and just a reminder for folks of where they can double check to see if they might be in a probationary period.
Right. Look, I think the best way to check is to look at the SF-50, which is a request for personnel action, or your SF-52 or other documents in your personnel file. But look, as a general matter, and I think this applies to 99.9% of your viewing audience. If you're less than a year, you're probationary. Even if you switch roles or switch agencies, the time you've served, quote unquote, as a probationary counts. Agencies could reset the clock, but they're going to have to take an affirmative step to do that and to notify you. So unless you receive that notification, time served matters, it counts. If you get past your 12 months, you're no longer a probationary employee. Now, if you become a supervisor, it's a different matter. You are also under probation as a supervisor, but, and this is an important but, you have retreat rights to a regular civil service job. You're not fired out the door. So again, two kinds of probations. Probationary employee writ large, 12 months or less, unless there's some other action on the part of the agency, whatever time you've served as a probation employee counts, regardless of changing roles or changing missions or changing agencies. And then you'll become a career conditional and eventually a career employee, and you get due process protections. If at some point in your career you are promoted to a supervisor, again, you're on probation, you got 12 months, but your retreat rights are back to your old civil service job or something equivalent. Make sense?
Yes, thanks, Ron. And I first of all appreciate everyone's questions in the Q&A. Really appreciate you sending those in, continuing to get to as many of those as we can. And one question that I'm seeing come up a bunch is if you could just speak a little bit more about the accepted service and the period that folks might be in there, and also briefly on what their rights might be in that position.
All right, we'll start with the last point first. If you're in the accepted service, many law enforcement officers are, many intelligence officers are, and suffice it to say that there are more than 500,000 federal employees who are now in the accepted service, in part because it comes with a lot more flexibility, both in terms of hiring and unfortunately in terms of firing. So as I suggested earlier, if you're in the accepted service, you're under what's called a trial period. That can be as long as 3 years. Depends on your agency. If you're a veteran, and there are lots of smart people smarter than me, who are still wrestling with this, but in my view, if you're a veteran in the accepted service, you never ever lose your right to appeal a removal, for example, or a conversion or whatever to the Merit Systems Protection Board. There are others who would debate that, but I can tell you that when I was in the intelligence community, 95% of our 100,000 or so employees, civilian employees, were in an accepted service. CIA, NSA, FBI, didn't matter. And they were on trial periods, in part because accepted service gives you more flexibility. But we always said, if you're a veteran, you never ever lose the right to appeal to MSPB, and we acted accordingly. Again, I'm going to just truth in lending. Others may take exception to that. But with 500,000 people now in the accepted service, and I should say services, although the purists who are watching would likely correct me, but CIA has its own, DOD has its own in the intelligence community and in cyber now, the so-called cyber accepted service. FBI and DEA have their own. SEC and the other banking regulation agencies have their own. So there are lots of accepted services, and they do provide more flexibility. My own advice to folks who think they may be is to go to their agency and just say, what are my rights and obligations and responsibilities if I'm in the accepted service. And let me add one other thing, Valerie. That's what the old Schedule F, now changed to say policy/career schedule. That's what it would do, is it would take employees who had regular civil service, competitive service protections, and put them into the accepted service. And that's all I'm going to say, because I'm as confused as the next person about what that's going to mean. The numbers are all over the map. If I were in charge, I would focus on a few hundred, if not a few thousand, GS-15s and senior executive service positions and equivalents, because they're the people who really make a decision about what government is going to do. I know that the National Treasury Employees Unions filed suit, and the numbers that they pulled out of the first Trump OMB were 5 figures, 50,000 plus. But again, suffice it to say, there's a lot of confusion over the Schedule F 2.0, and maybe we need to do another program or respond more in writing once we have a clearer picture.
It's a good moment to note that we are trying to do these webinars on timely topics every few days for the next several weeks. The schedule is on our website at ourpublicservice.org, and please let us know through this chat, through your registration for any of those webinars, what else you want to talk about, because we are gathering experts like Ron to help address questions like these. So Ron, we only have 15 minutes left. There's a few more topics that we wanted to get through tonight based on interest in the registration form. One was reassignments. We're definitely hearing about those in the news. People are experiencing them. I think the first question is, who can be reassigned? Are there different rules for GS employees versus SES employees? Is it different for union employees?
It may or may not be different for union, that is bargaining unit employees. That depends on the terms of their collective bargaining agreement. And even that, Valerie, has been thrown into confusion by one of the more recent executive orders. Suffice it to say, if you've got a collective bargaining agreement governing reassignments, I would try to exercise and enforce those rights, but let's set those aside. As a general matter, GS employees can be reassigned. It's voluntary. You do not have to accept it. If somebody says, you work in Atlanta, I'm going to reassign you to Denver, you don't have to take that. On the other hand, if your agency says, okay, if you don't take it, you're now surplus and we're going to run a reduction in force, then you have to suffer the consequences. If you're in the SES, by definition, you've signed a mobility agreement. So you have a different obligation if somebody gives you a reassignment notice. If I were in charge and I wanted to create headspace, I would say to SESers, you're going to move from Atlanta to Denver or from Houston to Chicago. If I'm an SESer, I got to take the job or I got to leave. And so you have fewer rights as an SESer, in part because by definition, you're mobile. Few agencies have exercised those mobility agreements. A few have in DoD for the most part. But I'm here to tell you, as a general matter, most SESers have come up through the ranks and have assumed that they're going to stay in their geographic location forever. If you're an SESer, sorry, that's not the case.
How much notice is it normal to get for that type of reassignment or relocation?
I don't know that provision of law by heart. I do know that SESers are entitled, and this is a matter of law, they are entitled to a 120-day get acquainted period when they have a new appointee. And in theory, that's what I would argue is the length of time I'm entitled to get before I have to exercise or take a reassignment. Give
Before
me a
they get a
chance to
new
prove my worth.
appointee?
Say again?
Okay. So before they get a new political leader in their office that they're reporting to, or 120 days to get to know that person.
Yes, but that is a separate provision of law. And again, I think that's an argument they can make. But as a general matter, if I'm an SESer in my agency, let's say it's me, I'm the career chief human capital officer or the career agency deputy or somebody like that, and that person says, SESer, I want you to move from Atlanta to Houston. You got to move or you got to leave. You can be terminated.
And if
Different
you,
if you're a GS employee.
yeah, that was my next question. If you're a GS employee, uh, what happens if you refuse the reassignment?
If you refuse, you're going to stay where you are. But again, if I'm an agency, I mean, at some point, if you stay where you are, the agency is going to say, wait a minute, you're now surplus. And if an agency is using the RIF scalpel, you are subject to being a victim if you stand pat. Now, if you're a very senior employee, let's say you're a GS 14 or 15, you've been around a long time, and somebody says, I want you to move from Atlanta to Chicago, and you say no. If the agency then says, okay, we're going to reduce headcount in this location, and we're going to run a reduction in force, the odds are that as a senior employee, you're not going to be laid off. But you've got a junior coworker who is liable to be heading out the door if you're not careful. And I will tell you one more DoD war story. When we were closing a naval shipyard, we had a whole bunch of employees take voluntary separation incentive pay. They were, in other words, they had committed to leaving. They all of a sudden decided they weren't. And frankly, we had already abolished their jobs. So they were SOL. You'll know what that means.
Yes, no need to spell out that acronym. Carrie,
It's a
what other
term of
questions?
art.
What other questions are we hearing live?
Now we're getting close on time, so I want to make sure we get to a topic I've seen asked several times throughout the webinar. Ron, if you could just explain to folks in plain language what admin leave is, and if there currently exist in the rules any limits on the use of admin leave.
There are limits on the use of administrative leave if, repeat, if you're under investigation. And Senator Grassley, a couple of years ago, championed legislation that put a cap on administrative leave for that purpose. What he found, and legitimately so, was that agencies are putting somebody in an administrative leave capacity for 6 months, 9 months, 12 months, 18 months, pending all sorts of investigations. And I think Senator Grassley and those who ultimately voted for that change, and there were a lot of them, bipartisan, basically said you can't do that. So there is a cap if you're under investigation. But even with that cap, agencies have pretty wide latitude. So again, I'll go back to something I said earlier. If an agency wants to say you're under administrative leave pending your future resignation, legally they can do that. We used to do that in the intelligence community all the time. We would take people off their jobs and put them in an admin leave capacity so that they wouldn't run afoul of procurement rules and other conflict of interest regulations while they were looking for other jobs, because we knew they were going to be looking for other jobs. So again, I think a lot of that depends on your agency and the latitude it has. But let's presume for the moment, if you're given an offer that says, I'm going to put you in an administrative leave capacity pending your resignation in May, June, July, August, whatever it is. If you trust that to be good and your own individual circumstances warrant it, I would take it. But if you're unsure, don't.
So I know we're close to running out of time, and Ron, I know you had some closing thoughts to share. I do want to say at a high level that um, some of the advice that we've heard very clearly on this call is one, if you haven't already, talk to your Chief Human Capital Officer or HR office about your specific circumstances and download a copy of your SF50 or a EOPF file to make sure you have that handy. Make sure that the information is correct in that file. I don't think we've talked about that yet, but I know I've been in a federal role where a few years of service were not accounted for until I noticed and asked them to make the connection. And make sure you know how to read your appointment type, your tenure, Block 24, your service type, and your position occupied.
Well, and Valerie, I'll go you one better. So let's go to the other extreme. If I were listening in, I'd make a copy of everything. Everything in your official personnel file, every piece of correspondence I get, both generally and specifically with respect to my own personal circumstance, I'd make a copy of everything because you never know. And I didn't get a chance to say this. If you're going to go seek legal advice, again, here's something to remember. If you go to your agency, those lawyers are there to represent the agency, not you. So think about having professional liability insurance. I learned my lesson early on in my career. I always carried it. I am not going to plug the insurance companies and the professional liability insurance companies that offer those services. That's between you and them. But I can tell you, but for that provision, I would have had to pay a lot in legal expenses because I had employees come after me. Eventually, I was exonerated, but I had employees come after me because they didn't like what I was doing. And I found very early on that the agency lawyers that I went to talk to weren't looking after me, they were looking after the agency. So just be advised of that.
And it's probably important to note that's just one option for legal support. As you said, look for external support, either privately, potentially private liability insurance. There's some union options as well, as I understand. Are there other places that people should look to for additional information?
Well, I wish I could tell them to go to their chief human capital officer. I think some are demonstrating courage by doing what we're doing this evening and telling employees, here's how we see it, here's what the rules say, et cetera, et cetera. Too many are basically hiding out of fear. I don't blame them, but at some point, HR staff's got to stand up and be counted. And Valerie, let me just piggyback on that and tell employees 3 things before we have to leave. Number 1, take a deep breath. Number 2, been there, done that. We've been through this. You may not have been personally, but the government has been. We have been through headcount reductions. I've mentioned my DoD experience. We've been through headcount increases. The reinventing government effort lopped off over 300,000 jobs, mostly in middle management. So we've been there, done that. Take a deep breath. It depends on your individual circumstances. It depends on your skills. It depends on your marketability. Pay attention to the deadlines, but don't become slaves to those deadlines. You've got to look after your own interests. But I will say in closing, and I've said this at the beginning, we need you now more than ever. Public service is a calling. Public servants have answered that call. And you need to stand tall now because while there are some, and I've got former colleagues of mine who have said the country voted overwhelmingly for this, what I told him in response is it's easy to vote overwhelmingly to cut federal spending. It's quite another to say no more foreign aid or no more Social Security Administration or no more Medicare or FDA or whatever. It becomes much more difficult. And as a result, at some point in the future, we're going to need civil servants more than ever. And frankly, we live in a democracy. So having political appointees who represent somebody who the people voted into office is not a bad thing. It's a good thing. And it's our sworn duty to help them, to find a way to navigate, not to just fight, not to just resist. And look, at the end of the day, the people have spoken. We should respect that and we should act accordingly. But again, I'll belabor the point. We need public servants who have answered the call. And even if it puts you at risk, the fact that you've answered the call is a good thing. And I would ask you to stand pat.
Yeah, it is right to finish exactly where you started, to thank everyone for your service, for the incredibly hard work that you're doing on behalf of the American people and the world. You are performing vital functions for our country, and please don't let anyone tell you otherwise.
Right.
So
And I got to tell you, Valerie, again, I was put in the very difficult position of having to tell thousands and thousands of employees, you helped us win the Cold War. Thank you for your service. Now, goodbye. That's very, very hard to do. It was harder for them because we were saying goodbye to them. But again, we need folks to stand tall, to play it out, to judge based on their own individual circumstances, respect the deadlines, but don't become a slave to them. And hopefully the public service will survive. I personally think it will. But I hope others like you are going to help to make that happen.
well, please do let us know, everyone here, what other topics you'd like us to cover. We are here to support you. Ron, I want to thank you for taking your time this evening to walk us through a lot of really difficult topics. And I know I learned a lot. I hope participants in the call did too. Thank you, everyone.
Look, let me just add one last war story. I apologize. When I worked in the private sector, we were told with 24 hours notice, stand by the phone. We'll call you if you have a job. That's the private sector, folks. So the fact that you've got rights and you've got a lot of them, and you can judge based on your own individual circumstances, and you can take a deep breath, and you have people like Valerie and I and others saying, thank you, thank you, thank you. That's a good thing, and it is different. If you're out in the world, in the wild, it would be far different.
A good sense of perspective. Well, thank you again, Ron. It's 7 p.m. We'll let everybody go back to your evenings, but we are here. Please let us know how we can support you.
Great.
Have a good night.